Assalamualaikum warahmatullahi wabarakatuh. Hi all, my name is Nada Agiltia Tamzil. I am the student of Batam International University 4th semester, student of Law Faculty, and my student identification number is 2051013. And I'm here right now to talk about Evasion of Law. This is a very interesting topic for your knowledge, so keep on watching. Evasion of law has several terms, but I'd like to clarify first that I might not be able to spell it correctly, but here I am trying my best to give an information, so let's continue. In Netherlands, they call it wetsendiking, meaning law evasion. In French, they call it fraude à la loi, meaning defrauding the law. In Latin, they call it fraude legis, meaning fraud of the law. In German, they call it Gesetzesumgehung, meaning circumvention of the law. In English, they call it fraudulent creation of point of contacts. And lastly, in Italy, they call it fraude alla legge, meaning fraud of the law. So the definition of evasion of law is basically a foreign regulations that sometimes set aside and use national law or otherwise for certain advantages or purposes. Evasion of law is an act committed in a foreign country and recognized as legal in that country, but can also be cancelled or not recognized by the forum if the act is carried out in the foreign country concerned to avoid the lax rules that prohibit such actions from being carried out in the forum area. So, even if the act is carried out to escape the national law, the judge who handles or resolves the case that related to this act will continue to apply the national law and declare that evasion of law to be invalid. Evasion of law occurs if there is a person who, in order to obtain the entry into force of foreign law, has carried out an unjustified method with the intention to avoid the use of national law, with the aim of avoiding a condition or a certain unwanted legal consequence, or to realize or even to desire a legal consequence. In other words, someone commits evasion of law with the aim of enforcing a law that is different from the law that should be used. The characteristic of evasion of law is using private international law for certain purposes, as I said before, so that non-legal relationships are treated by a different law than the law that should be used. The purpose of evasion of law is to be able to avoid an unwanted legal consequence or to realize or to desire a legal consequence. The consequences of evasion of law is any evasion of law results in the cancellation of the action. There is also a well-known expression, which is res omnia corrumpit, meaning that the evasion of law results in that the legal act is totally invalid. So now let's move on to the study case. And evasion of law is still in the scope of private international law. So it is a case considered to private international law matters, and I'm going to explain that later. So now let's continue first. I took this case from court decision number 31/PDT.G/2013/PN.PRA. The plaintiff is Jason Scott Pickering, male, Australian citizen holding Australian passport, private employment, currently having his address at Raya Kuta Road, Kuta Village, Bujut District, Central, Lombok Regency. Gave power of attorney to Emil Siayin, Ayu Irma, Alam Syah Dahlan, and Bambang Hardianto, advocates domiciled in the Office of Advocates and Legal Consultant, Emil Siayin and Partners. This case has 4 defendants. The first defendant is Ida Bagus Putu Pramata, second defendant is Umar, third defendant is Dewi Ratna Ayuwati, and the fourth defendant is Adnan. They gave power of attorney to Lalu Rusmat, advocate or lawyer addressed at Sultan Hasanuddin Road, number 10, Praia Central, Lombok, based on a special power of attorney dated 12 November 2012. The plaintiff filed his lawsuit on 10 June 2013 at the Praia District Court. Now let's go back to why is this case considered to private international law. Let me separate these two words first. Private law and international law. What is private law? Private law is a law that regulates the interest between legal subjects and another legal subjects. In this case is between the plaintiff and the defendants. So this case raises the dispute between the plaintiff and the defendant. We also have international law. International law is a law that regulates the activities of international entities. The parties of this case has two different nationalities. The plaintiff is a resident of foreign citizen, which is Australian citizen, while the defendants are Indonesian citizen. The object of the dispute is in Indonesia. The legal issue occurred in Indonesia. The case submitted in Indonesia by foreign citizens. So basically, that is the reason why this case is considered to private international law. Now let's move on to the chronology. The plaintiff and defendant 1 became acquainted in Bali. The plaintiff revealed to defendant 1 his desire to invest in Bali, and defendant 1 then offered a number of lands to the plaintiff, which was located around Sanur Bali. The plaintiff and defendant 1 came to Kuta village, Puju district, Central Lombok Regency to find the location of the land desired by the plaintiff. And at that time, defendant 1 introduced the plaintiff to defendant 2, who claimed to be the owner of the land, while defendant 4 was also present there and introduced himself as the head of the village. The plaintiff stated that he is interested in the location of the land and inquired about the status of ownership and land titles to defendant 2, and he stated that the land is belong to him, which is currently being submitted for a certificate application process. This was also confirmed by defendant 4, who at that time he stated that the land is secure and guaranteed, and stated that he is a representative of the government and could provide all necessary permits as well as the building permit. Defendant 1 conveyed to the plaintiff that the price of the land is 60 million rupiah per acre, whereas to defendant 2, defendant 1 asked the price of the land to be 40 million rupiah per acre. Plaintiff didn't know that there was a trick of defendant 1 and defendant 2. And finally, it was agreed that the total price for the land approximately 1,200,000,000 rupiah. On 19 February 2010, before Notary Muhammad Ali in Mataram, issued authentic deed regarding the sales and purchase agreement number 20 and letter of authority number 21 between defendant 1. In this case, he represents the plaintiff as the buyer because at that time he didn't have the foreign capital investment. With defendant 2 and defendant 3, in this case, defendant 3 represented as the wife of defendant 2. At that time, the first stage payment was made of 220 million rupiah by defendant 1, who represented the plaintiff, to defendant 2 and defendant 3 witnessed by witnesses of defendant 4. But later, the plaintiff found out that when defendant 2 were conducting transactions at Notary Muhammad Ali, the certificate application file shown by defendant 2 during the transaction at Notary Muhammad Ali was never submitted for certificate. And to make his argument stronger, he already asked for a copy of the application form, which was addressed to the Minister of State for Head of National Land Agency of Central Lombok Regency, signed by defendant 2 as the applicant along with the other supporting documents, but defendant 1 and defendant 2 never submitted the application to the National Land Agency office for processing in order to obtain the land rights. And also, in that sale and purchase agreement, the second or subsequent stage of payment will be paid after the certificate has been processed by defendant 1. However, in reality, defendant 2 cooperates with defendant 1, continuously demanding the plaintiffs to make subsequent payments for various reasons, including costs are needed because the wife of defendant 2, defendant 3 is about to give birth, and various other reasons. Due to the pressure and demand, the plaintiff made several payments to defendant 2 through defendant 1 by cash or account transfer, and the total payment received by defendant 2 and defendant 3 was 1,085,400,000 rupiah. Now let's move on to the plaintiff's and defendant's argument. The land certificate purchased by the plaintiff was never happened and never submitted for the application process for the certificate. The land certificate purchased by the plaintiff was never happened and never submitted for the application process for the certificate. The plaintiff suffered an actual loss in the form of money for the purchase of the land and money that has been invested to build the hotel and all its supporting facilities, and he also suffered a large moral damage. The defendant must pay compensation and place a confiscation of collateral to guarantee the fulfillment of compensation. Now, from the defendant's argument, they think that the plaintiff's lawsuit has no legal basis because of the sale and purchase agreement of the land is prohibited by law. Because the purpose of agreement result in the transfer of ownership of land belonging to Indonesian citizen, which is defendant 2 and defendant 3, to the plaintiff who is a foreign citizen, so it is forbidden to continue. Defendant 2 and defendant 3 have absolutely no legal relationship with the plaintiff. They only entered into a sell and purchase agreement with defendant 1, and they think it was impossible to enter into sell and purchase agreement with the plaintiff because the plaintiff is a foreign citizen who is not allowed to own lands in Indonesia. Defendant 4 has absolutely no legal relationships with the plaintiff or the other defendants. The legal issue of this case is breach of contract with the object land certificate of land covering an area 2,000 square meter. The consideration of the court is that the plaintiff's lawsuit considered an obscure label, and the plaintiff's lawsuit must be declared unacceptable because of some reasons. The first reason is that the plaintiff's arguments are contradictory. Defendant 2 and defendant 3 had no legal relationship with the plaintiff because it's impossible to enter into sell and purchase agreement with the plaintiff because the plaintiff is a foreign citizen who can't own land in Indonesia. The legal relationship between the plaintiff and the defendants over the object of the dispute is a legal relationship that is prohibited by law. Because the plaintiff is not an Indonesian citizen, but a foreign citizen, which is Australian citizen, who is not allowed to own land in Indonesia. And also based on Article 9 of Law Number 5 in 1960, the agrarian law, and therefore every legal relationship in the form of buying and selling, inheritance, grants, and other wills that may result in legal consequences for the transfer of land rights, either directly or indirectly, to foreigners is null and void. The court decision are accepting the exceptions or arguments of the defendants in part, and stating that the plaintiff's lawsuit is an obscurity or unclear, and declare that the plaintiff's claim is unacceptable, and sentencing the plaintiff to pay court fees of 1,811,000 rupiah. The plaintiff also bring this case to the Indonesian Supreme Court, but still get the same court decision that the plaintiff's lawsuit unacceptable and obscure label. You may be wondering what is the connection between this sample case and Evasion of Law. Based on Law Number 5 of 1960 concerning basic agrarian regulations, foreign citizens can only have the right to use and the right to lease on the land. The plaintiff is a foreign citizen who cannot have ownership rights and obtain a certificate of ownership of the land. So, this is an act of evasion of law that ignores the laws of a country to obtain a certain goals and benefits. And that's all I have for my video about evasion of law. I am still a college student who still have an eager to learn and still trying to give all my best for this video. And I'm sorry if there is a lot of mistake that I have done. But thank you for watching. Bye bye.